change our analysis at all? And I'm asking because I don't know.
Well, no, I don't. And that's really one of the main points I wanted to make with respect to the dismissal of the fraud claim. Let's keep in mind, the plaintiff had two chances at the trial court level to plead this fraud claim. And in neither instance could the trial court understand what exactly is the fraud.
Well, let's assume we're real better at detecting fraud than the trial court. So then what?
Well, this is where I think why the court made the decision in part, not just because the particularity, of course, was one of them. But I think if this court were to accept the appellant's position on this fraud claim, it does open the door to allowing a plaintiff to turn any breach of contract claim or a contract claim over real estate into a fraud claim simply because they don't like the way the deal turned out. That's the lacrosse case that we cited. It was over negotiations, and they were trying to turn them into a fraud claim. And in this particular case, the fraud claim and the separate defendant, Mr. Long, they was added to weaponize what was otherwise a civil dispute. It was to increase the adversarial nature, to attack somebody's personal reputation. This fraud claim was used to expose Mr. Long. You know, fraud's not covered by insurance. The stakes are so high with these kind of claims. That's why they have their own set of rules, these safeguards. And I'm asking this court to uphold those safeguards because they really were in play in this particular case. That was the purpose of that fraud allegation, and the trial court knew it. This was a breach of contract at the very most. Of course, we argue it wasn't even a breach of contract, but it certainly was not a fraud.
I'd like you to turn to why this was not a breach of contract. Why was this not an anticipatory breach?
I think this goes to, in my view, I think the crux of this case or this dispute comes down to what the appellant has argued, and I counted at least 3, 4, maybe 5 different times in its brief, whether it's the fraud or it's the breach of contract or anything else. Delivery of marketable fee simple title free of all liens and encumbrances was promised by seller and not delivered. That's the issue. And the problem is there's no promise in the contract to deliver marketable title free of all liens and encumbrances. There can't be a breach of that promise when it doesn't exist. And even in their own brief, when they reference the court to where this promise was made, who made it, they cite to the contract. Well, they don't tell you where in the contract it says that because they can't.
Well, it says you'll deliver title insurance
Right.
to the market value of.
You deliver a title insurance and a warranty deed at closing. We never even got to closing because the contract terminated well before that under Section 8. But my point is, there was never any promise to deliver title free and clear of all liens and encumbrances. That may have been the wish and desire of Mr. Bogina, but that was never an obligation of the seller. And that only makes sense. Let's just say, for example, this Beacon judgment lien was for $1 million. Does that mean just because it was listed as a requirement on a title commitment that Mr. Long has now obligated himself by contract to resolve $1 million judgment lien, even if Beacon wasn't agreeable?
So what do you think this means, the first sentence in Section 8? That seller shall deliver and pay for an owner's title insurance policy.
Right?
What does that mean? What's the obligation there?
Seller delivers a title commitment. We look at, let me get
Ensuring
this.
marketable fee simple title and buyer in the amount of the purchase price. So was that delivered?
It was.
Okay.
The title commitment was delivered.
Ensuring marketable fee simple title and buyer in the amount of the purchase price.
Let me get to my contract so I can follow along. Seller shall deliver and pay for owner's ATLA title insurance policy, issuing marketable fee simple title in buyer in the amount of the purchase price. Okay, as of the time and date of recording of seller's warranty deed, which is at closing. So no, we didn't get that far.
Okay,
We did not have to deliver that because the contract terminated before that obligation arose.
because it's your position there was an objection.
There was an objection and it wasn't waived or resolved.
Okay, so let me ask you this. Let's say we don't think there was an objection. Okay,
No objection by the buyer to anything on the title
no
commitment.
objection to the beacon. Are you saying that this section, then, if there's no objection, is it your contention then that sellers don't have to resolve the issues in order to deliver the insurance policy?
Yes. This, as a matter of fact, that is what I'm trying to say. The title commitment is not this cloud clearing mechanism that the appellant is trying to establish here. For the reason I just laid out, it can't be.
Sure, I just want to know in the contract, if there were no objection, you're saying that the contract provides that he would not have to, that the sellers would not have to provide that.
If there was no objection, that means the buyer is accepting all of the encumbrances.
Okay,
So what would the seller have to do?
I'm just clarifying what we're talking about here with regard to the objection versus the non-objection. So if there was no objection, then the buyer accepts the encumbrance on it.
Those are permitted.
And then would it have issued? So this is what I'd asked him before. If it was left there, would it have issued the same insurance policy, market value, fee simple, et cetera? Would the insurance policy have issued?
Yes, because
Okay.
they've been accepted.
Okay,
But again, yes, we didn't get that far because it terminated, so back to what I was saying about this marketable title, and free of all liens and encumbrances. I don't think it really matters because the contract simply terminated, and I don't know that that's even in dispute. I guess they just don't like the timeline. They think that it did terminate, but there was a breach before the termination,
when do you think it terminated?
December 30th.
Okay.
Yeah. It was pretty straightforward. I also think all of the first title commitment and all of the timeline up until we get to the actual title commitment that the buyer's attorney is objecting to is irrelevant. Who cares what the first title commitment said? That's not what is the operative title commitment. The one that was operative was the last one from Chicago Title in December of 21. And that's the one that the buyer's attorney, Mark Bodine, wrote his objections. And I think it is important. This was mentioned by the appellate counsel, but this is an important detail. The objections that were made by Mr. Bodine. This goes to the issue of what is the distinction between a requirement and an exception? Does it even matter? And in this case, it doesn't. I don't think it matters in any case because under Section 8, it says any matter in the title commitment that's either in it or referred to in it. Mr. Bodine's objections in the record, in writing, he characterizes the Beacon judgment lien as an exception that he's objecting to under Section 8 of the contract. He's clearly parking these objections right into that part of the contract. So for counsel to take the position now that, well, not really, he couldn't have, that isn't what he meant, or because there was an addendum before that that referred to the declarations, that's maybe outside Section 8, it wasn't. The buyer's attorney clearly put these objections, and it's pretty simple. It's the Beacon lien, it's the condominium declarations, and then he wanted things that aren't even required under the contract, like endorsements to the title insurance policy and all these other things. That then shifted to the seller. Are you going to do this stuff or not? And he clearly said, I'm not going to do it. And then it went back to the buyer to say, am I okay with that? Do I want a different price? What do I want to do? And he wasn't. He didn't waive them. and it terminated. That's how these deals have to work. Again, what if there was $1 million lien? What if there's a gas easement, which there was, and there's a gas line? Just because it's a requirement in the title commitment, does that now mean the seller has to get rid of a gas line to make the deal close? Deals fail all the time, and just because they do doesn't give rise to fraud. This buyer was upset because he spent money early when he shouldn't have. That's why this Section 8's in the contract. That's the purpose of it. Make sure that you have an agreement with your seller about what you are and are not comfortable with on the title before you start spending money on zoning and due diligence and all this stuff.
Well, it was required that that be done within, what, 120 days of the contract or something?
The title cure
The due
period.
diligence. So that's probably why I did it early. It was required to be done pretty early.
I remember this issue coming up, and
Oh, it's okay.
I feel like there was an extended time for that, but I understand the court's point.
So does it clear up something for me, because I don't fully understand about the replat running with the property. Does it not run the replat, or is it specific to the buyer?
The replat, when you're talking about the condominium declaration,
No, I'm talking about what the buyer went to the city commission to have done, changes to the land, what they're alleging their outlay of expense was.
I see. And the question again,
Does it run with the property?
I suppose, although I think the issue is, did it really improve the value at all?
Isn't that a fact question?
It is, I suppose. But yes, I think if you were to look now, whatever he did is probably still in place on that particular parcel until it's reversed or changed or rezoned or whatever. Yeah. But again, my position would be he did that at his own peril. He had a contractual mechanism to allow him to work through these issues first before he did that.
And if he hadn't objected and he would have waived it, then he would have deemed to accept the Beacon judgment, and it would have moved to section B2. It would have become an exception instead of a requirement.
Permitted exception.
Yep. And then the insurance policy would have still issued.
Yeah.
Can you ask that question again?
Counsel.
Sorry, I was.
Sorry. If there had been no objection, he waived and accepted the Beacon judgment as a burden, then in the title company's commitment or whatever, it would have moved from section B1 as a requirement to section B2 as an exception. And then the title insurance would have issued. Because he's arguing it was under there as a requirement, right? Which means you have to do it, et cetera, et cetera. But the contract says that if you waive, then it becomes an exception. So I'm just trying to understand what would have happened if it would have just stayed on.
What would have happened if there had been no objection to the Beacon judgment lien?
Mhm.
I mean, I think you've got it. I mean, under this contract language, it would become a permitted exception.
Okay, I'm just trying to make sure that I'm
Yeah.
completely understanding. All right.
Your Honor, I don't think I have anything further.
Are there any other questions from the panel? All right, thank you very much.
Thank you.
Thank you.
Counsel, you have 4 minutes for rebuttal.
And I apologize for asking for, the old litigator in me pops out, but I want to make sure I heard the question because it was, and I'm going to start with that question. So in Kansas, under KSA 582203, a warranty deed is defined. What's required in a warranty deed, which is what was to be delivered here. You're supposed to convey fee simple. There's a lot of other language in there to it, but it says that, free of all encumbrances and the grantor will warrant and defend the same against all lawful claims. That's the definition of a warranty deed. So that, when this contract, that's a statutory piece of language. And I would tell you that I do not agree that if you don't object to this under the contract, it changes the title company's terms. Title company is not a party to the real estate purchase agreement. If you look at the ALTA commitment for title insurance, which is volume 5, page, looks like 53, there's exhibit stickers over it. It specifically says this commitment is an offer to issue one or more of the insurance policies. So, and then you go on through a bunch of disclaimer language, subject to the notice, Schedule B, Part 1 requirements, Schedule B, Part 2 exceptions. It defines who's going to be insured, that it's going to be a fee simple interest. And then an exhibit, part of that exhibit, Schedule B, Part 1, it provides that these shall be, all of the following requirements must be met.
Right, but as you said, it's an offer. I mean, this can obviously be negotiated and changed.
And that is not, there was no amendment to this agreement that which is what Mr. Long was trying to get into, which is, well, seller or buyer, you need to take that. Our position is he agreed to deliver two things. One, the policy, ensuring marketable fee simple title, and also a warranty deed. That's what he agreed. There were two things. That's in paragraph 8. And,
Counsel, what say you though to his argument that that wasn't his duty to deliver until closing?
well, and so our position is on that, once the title policy issues and says seller, this is what is required to give you a title, then sellers accepted that. They're going to do those things to issue a title. And these lien things come up all the time, and they're escrowed, and then the seller goes and takes care of them. You can also negotiate this with Chicago Title. You have to negotiate moving it from Schedule B1 to 2. And there is then paperwork that comes along with that from Chicago Title that the buyer has to sign, acknowledging that's risk, that title could be compromised to the extent of that. None of that occurred. The seller did none of that. There's no indication that all that he did was have some arguments of, well, maybe this shouldn't even be on here. And then if you look at what they deliver at closing, it does provide what he's supposed to deliver at closing, and it's paragraph 13. And it says that they won't distribute funds to seller until the deed or the instrument conveyance is signed and provided. If there's a mortgage, and the title company can issue the title policy with only the permitted exceptions. We don't have that either. And so,
But it could have become a permitted exception.
not by failing to object. Your Honor asked if we didn't object, did it become a permitted exception? Not between the title company and the seller.
Right.
They're the ones on the hook for ensuring the title. So that's why I asked
Is it your contention though, that then anything that comes up on a title, when they run for title insurance must be cured by a seller?
Schedule B or Schedule B, Section 1. Yes, the requirements, because those are the ones where the title company says, we offer to give you title insurance if you do this. If these things are met. And most of these things, what's interesting about this and this one, most of these, have to do with the corporate documents and all that. We also don't have any of that. This is where the issues of fact are important. There's Mr. Long was giving his corporate documents to the prior title company as they were moving along. At this point, the corporate documents they were asking for.
Right, but the only thing we're really talking about here.
Sure. Absolutely. Yes. But I'm just saying there's no trial on the facts for the court to evaluate, like the letter where the exchange between Mr. Bodine and Mr. Long, where he says, we have a telephone call scheduled this afternoon before the time had ran to discuss these other items. That's all I have. Thank you.
Thank you very much.
Thank you.
Thank you, council. Thank you for the arguments, for your briefs, for your oral arguments today. We'll take the matter under advisement and get a written decision out as soon as we're able. And at this point, the court stands in recess or stands adjourned.
So good afternoon.